Welcome back. This is breaking news. The Justice Srikrishna report, which was probing the role of Chanda Kocchar in the Videocon case, is out. And basically, it finds Chanda Kocchar was in violation of ICICI's code of conduct. And how was it in violation? She did not deliver on her fiduciary responsibility. Which were those fiduciary responsibilities? Of disclosures. Basically, what the report finds her guilty of is not disclosing the interest that her family had with Videocon, as well as not recusing herself. So it's basically, you can say, two things that they are finding her guilty of. First, not disclosing the connection with the person who was getting the loan, as well not recusing herself and therefore not participating in the decision to grant a loan. But there are no implications on the published financial statements, which means that it wasn't as if Videocon's loan went bad or it got a lower interest or different covenants because she participated. It is more her behavior, which is not recusing herself and not disclosing her interest, that they seem to be found guilty. But that's the first 4 paragraphs.
In fact, Chanda Kocchar resigned as of October 2018, even before the results of this report were known. Now, the bank says that the board of directors have decided to treat the separation of Chanda Kocchar from the bank as termination for cause under the bank's policies, with all intended consequences, including revocation of her existing and future entitlements, and they require the clawback of all bonuses that have been paid to Chanda Kocchar from April of 2009 until March 2018, and to take such further actions as may be warranted in the matter. So, they've cited this as the term, the reason for the termination of her appointment with ICICI Bank, and sought a clawback of all the bonuses that have been paid over the last 10 years. Okay,
so that is what was diagnosed as the mistake and the penalty that the report has, that the committee has imposed. Now, we just want to read to you verbatim what is written. So I'll begin with the charges levied by the inquiry report. And I'm reading it verbatim so that our paraphrase is not coming in the way. The inquiry report with the scope period of April 1, 2009 to March 31, 2018. 1 minute. Unless specific information required inquiry into transactions or facts of an earlier period, concluded primarily on account of ineffectively dealing with conflict of interest. Let me read that again without the brackets, the parenthesis. The inquiry report with the scope period of April 1, 2009 to March 31, 2018 concluded primarily on account of ineffectively dealing with conflict of interest and due disclosure or recusal requirements that Chanda Kocchar was in violation of the ICICI Bank Code of Conduct, its framework for dealing with conflict of interest and fiduciary duties, and in terms of applicable Indian laws, rules and regulation. The inquiry report also concluded that her lack of diligence with respect to annual disclosures as required by the bank in terms of its internal policies, the ICICI Bank Code of Conduct and applicable Indian laws, rules and regulations,
what is important?
The bank's processes were dependent solely on the directors discharging their fiduciary duty to recuse themselves and avoid conflict, implies that the bank's process were rendered ineffective by her approach to such disclosures and avoidance of conflict. So basically this sentence seems to say that the bank's processes are good, but Chanda Kocchar did not follow those processes. She did not disclose and she did not recuse. So maybe you want to read the penalty portion as well.
The penalty portion, of course, says that the board of directors have decided to treat the separation of Ms. Chanda Kocchar from the bank as termination for cause under the bank's internal policies, schemes and code of conduct, with all the attendant consequences. Further, they require the clawback of all bonuses that have been paid from April 2009 until March 2018, and to take such further actions as may be warranted. What is important is that the bank has sort of, set itself, distanced itself from the entire controversy, saying it was, the singular act of one person and her failure to disclose that caused this lapse, and it was not really the bank's problem. The bank's due diligence process was followed. It was only because, she she rendered it ineffective in her approach by not making this annual declaration. So clearly the sole blame, it seems here, has been pointed towards Chanda Kocchar alone.
But the report goes on to say that the financial statements are clean, are not affected. And they also note, and I think this is important because they want to avoid class action suits. The bank notes that there are no implications of the inquiry report on its published financial statements, Indian or US GAAP, for the relevant period. It's an NYSE listed stock. And so any admission of such guilt could open the doors, invite class action suits or other problems, and that is why they are saying, the report is saying that the financial statements are safe and not tainted by the lack of disclosure on the part of the then managing director. We have some experts joining us, Jane Gupta, former ED of SEBI, and a person who runs a proxy advisory firm, SES. We are also joined by Sriram Subramanian of InGovern. Mr. Gupta, your first thoughts on what the inquiry report finds guilty? Lack of disclosure, not recusing.
I think it is a massive blow, but it raises a very, very big question. The big question is, what about the board of ICICI? The reason I am saying is this, because when this thing came into light, the first thing the board, without even twinkling the eye, said that we have full faith in Chanda Kocchar and we have conducted an inquiry and there is nothing wrong. Now, when Justice Srikrishna finds that Chanda Kocchar failed to follow the internal code of conduct, now I am surprised if a justice is required to find that there is a failure, that somebody has failed to follow the internal code of conduct, then what the board was doing? The board gave a clean chit to Chanda Kocchar. So the question that is being raised and the reputation will be raised is that those people who were sitting in the board of ICICI at that particular time and who gave clean chit, whether they gave clean chit in the hurry or they were part of the whole process.
Yeah, those questions would definitely rise, Mr. Gupta. But, let me take first comments from the other experts. And I want to come back to you to ask you whether the board was only the guardian of the financial statement. And according to the inquiry report, the financial statement is safe. This was only an act of disclosure which was lacking, an act of recusing which was lacking. I'll come back to you with that question. Sriram Subramanian, your first thoughts about the indictment and the penalty?
No, I would be curious to know whether, how the Justice Srikrishna report would have read before the CBI charges had been filed.
Oh, that's a little unfair, isn't it? It's quite possible that it was prepared even before. After all, the CBI's FIR was only last week.
January 24th.
It's quite possible that he wrote it earlier.
I'm not hazarding any guess here.
Okay.
Let's take it at face value. And secondly, definitely, again, this brings to light the role of, or the importance that is given to star CEOs and the role of the board. So the equation between a star CEO and the board is something, I think, that is getting slowly defined in corporate India. And again here, a star CEO to step off the line, and even when there was a whistleblower report, the board just went and sort of said there is nothing wrong, and they didn't even conduct an inquiry. So at the very least, I think the board should have said our primacy is to shareholders, and then conducted an inquiry. And this is, I think, more important going forward for corporate India.
No, I think both Mr. Gupta and Sriram are pointing out to the same thing.
But Mr. Parekh, Sandeep Parekh is also with us. How do you read this? Do you think it's a clean chit to the board and all the blame solely lies on Chanda Kocchar for her non-disclosure?
See, the basis on which the report is made, of course, we don't know the facts. We've known the facts through media reports over the past one or 2 years. But given that they've looked at the facts in detail, they seem to have determined that, any kind of conflict of interest has to be disclosed by a particular person. And, a board cannot predict what conflicts of interest exist. And I think, broadly, it sounds right. And, essentially, unless a person discloses that his or her husband or wife are kind of having a side deal, with the borrower. It's impossible for, unless they are fortune tellers, it's impossible for the board to come to know. So I think the role of a board is not really to be a bloodhound. What comes to the board, of course, they should and must look at it with care, diligence, and loyalty. But beyond that, unless they had a red flag and they avoided seeing the red flag, which of course we can get into, and that's a separate question, because there were red flags and whistleblowers and all that kind of stuff. So, but broadly, I think it seems to be in line with common sense that if there is some breach of related party transaction, some side benefit which one director got, it's incumbent on that person to disclose it, and it's impossible for the board to kind of predict it.
Okay, what would you say now, Mr. Gupta? Do you think the duty of the board was to protect the balance sheet and the financial statement, and if they are confident that there were enough people in the credit committee who would have ensured that the interests of ICICI is protected, that the covenants were similar to the covenants that SBI imposed on the Videocon loan, and the board was satisfied with that. Therefore, would you still say, I mean, this report is not casting any aspersions on the board because the financial statement, according to them, also is safe. Do you think that is a fair argument?
I would begin with, as Sriram said, I would say that the casting in aspersion on Justice Srikrishna is beyond my imagination, so I would not speak on that. The second issue is this: I would slightly disagree with Sandeep on that issue. In normal course, board is not supposed to be bloodhound or forensic accounting, but when there have been reports of some whistleblower and something, and then in hurriedly giving a clean chit, I would say it may be a rash act on the part of the board, or maybe they had also gone by the star value of Chanda Kocchar.
Yes. So I think this boards being in awe of their CEOs is something that India Inc. has to come to terms with and correct.
Second issue that I am saying, that listen, this is only a report which has come only on the procedural aspect.
Absolutely, yeah.
It doesn't get into any criminality aspect of it.
Absolutely, Mr. Gupta, and therefore, nothing on whether or not...
So, Mr. Gupta, therefore?
Therefore, I would say that it is just the beginning of the probe that is coming out. Now, with CBI on this, you do not know whether it was only Chanda Kocchar as a loan banker involved in something, or it was a consortium of banks who were also responsible. Because I would say that it is impossible in a loan of such a huge magnitude where more than one bank or maybe half a dozen banks were involved, only one person could have been a wrongdoer.
No, Mr. Gupta, Justice Srikrishna is saying that the Justice Srikrishna is not saying that she profited from the loan or she gave a loan to the advantage of the borrower. He is only saying you should have recused, you should have disclosed, isn't it?
I agree. That is one thing. The Justice Krishna's domain was not at all to go into that. That criminality aspect will be examined separately, because Justice Krishna only limited on what was the board duty that Chanda Kocchar was having, what was responsible, and whether she did or not. So criminality angle has not been examined till now.
But he has gone ahead and said that there are there is no impact. The bank notes that there. This is the bank notes. Sorry. He does not note. I'm sorry. Mr. Justice Srikrishna is not making a comment on the published financial statements. The bank is making. I'm sorry.
Bank has not done any of those investigation which generally investigative agency does. So I would say this inquiry is limited purely to the procedural part. It is nothing to go into anything else. But then again, it brings to four very simple question: whether a person who has been there for long, just because of his weight that he or she carries, should policy be designed on that basis, or the policy should be person neutral. It should be agnostic to the person's reputation. I and you should be treated the same way at airport as any other person. This is what.
But you are not getting that feeling from this report? that...
No, I'm not. I'm getting a feeling from this report from Justice Srikrishna.
Yes.
But I was not getting the same
From the board.
feeling when the board had
right.
given a clean
Fair enough. Fair enough. Okay, Sriram, Sandeep, I wanted to ask you, will this worsen Chanda Kochar's position in the CBI case? Will it be a fodder, or it does not move that case any which way?
See, it will have some psychological impact, but as you know, criminal law requires a far higher burden of proof. So the evidence which is required is, to put it mathematically for a civil case, or in this case is actually an administrative case where it's an in-house, housekeeping kind of stuff. The burden of proof is like 70-80%. Whereas a criminal case, it has to be 99% plus burden of proof. So it doesn't turn the needle there, but it does certainly kind of it will have some impact in that case.
Okay.
Conversely, I think it will have a hugely beneficial impact on the other board members and the credit committee members who have been named without kind of with innuendo rather than charged as prima facie case.
Okay.
So I think what Mr. Arun Jaitley tweeted will get support with this.
Okay, I also wanted to know about the gravity of the penalty. Sriram, do you think it is excessive? Do you think it is appropriate?
I think, given the fact that over this time frame, she has been CEO, so from that perspective, clawback and all is quite appropriate. And this is the kind of penalty I think corporate India needs from the perspective of especially when there is clear evidence, I would think, with Justice Srikrishna, and that is the kind of impact that investors and shareholders are also expecting that a company take if there is any fraudulent or behavior by CEOs and management. So here, of course, as Sandeep said, there is a procedural lapse, but even that can have grave consequences.
Lata, let me just point this out. When the bank had set up this committee on the 30th of May, last year, the scope of the inquiry was much broader. It was not restricted to, just the due process being followed. In the bank's own statement, it says, it would examine all, with the conflict of interest, alleged quid pro quo in the course of work, all aspects of this allegation that had been made had to be examined by this committee that was set up under Justice Srikrishna. And therefore, perhaps, this is only one part of the report that has been made public, where the bank wants to reiterate that there's no implication on the financials. Perhaps the larger part of the report on whether or not there were any kickbacks, whether there was any wrongdoing or influencing by the, the credit committee or Chanda Kocchar at that point of time, that part of the report has not really been made public because the scope of the inquiry was very clear. I'm just reading that 30th May notification. It was not to restrict itself to only the financial implications, but, largely establish whether or not, there were any kickbacks at all, and all the implications surrounding that.
Okay, so what you're saying is that there may be still parts of this report which we need to know on whether it pronounces if the MD benefited from her position or misused her position for personal gain.
Absolutely. I think that part of the report is something that has not been made public. But of course, there is a CBI FIR now in the matter. So I don't know, perhaps that would also have a larger consequence. This is just, the first bit of the report, I believe, where the bank is trying to make its position clear that at least financially, there have been no implications of the lack of disclosure on the part of its former MD and CEO.
Okay. Well, that puts a different spin on everything. It will mean that there could be more disclosures in the report. Perhaps CBI will ask for that report and that might actually give proof to CBI in terms of any kickbacks that Chanda Kocchar may have got because of, this loan approval. Hetal Dalal of IIAS is also with us, again, another proxy investor firm. Do you think an ICICI Bank investor is well served with this press release? Hetal, do you think they can rest in peace that at least the accounts or any class action suits, etc., will not befall the bank?
Look, I think the issue was always that the bank had followed due process, and whether there was a conflict of interest and whether that had to be disclosed by Chanda Kocchar. So to the extent of saying that there's no real implication on the financial statements of ICICI Bank, I think is reasonably expected. Whether it results in a class action suit or not is really dependent upon, where they're going to look at enforcement on the conflict of interest policy. And given that she's a CEO and she's been found guilty of a violation of the conflict of interest policy, more so in a bank, I think that's going to be an important issue that investors will consider.
Okay.
But Hetal, what do you make of the kind of penalty, so to speak, that the bank has now imposed on Chanda Kocchar, the clawback of all the bonuses that have been paid to her in the last 10 years?
Yeah, well, I think a clawback is necessary because that is, a way in which also the bank has to censure this lapse. And to that extent, I think this is possibly also being, looked at as an example of how the bank is also reacting to a situation like this. So to that extent, I think, yes, a clawback is necessary. Whether a clawback all the way from 2009 to now, perhaps is, I'm sure Justice Srikrishna and the committee have a rationale to it. But it's too long. It's a very long period.
Okay. Mr. Parekh, what do you make of the fact that, the Justice Srikrishna panel was supposed to conduct a comprehensive inquiry into kickbacks, into conflict of interest, into processes being followed? Do you think we've only seen part of the investigation, perhaps, a more detailed public report, if that is to be made of the matter, that would throw more light on all of this?
I mean, that's a factual question. It's hard for me to tell you whether something is there in the report which is not shared in the press release. But I think the previous question, I think I have a perspective, which is, it's pretty hard to judge which way the entire episode is really going to move forward with, including many issues which you discussed, class action, etc. Because right now we're just saying, part of the report. But once things are more clear, I think there will be obviously be consequences, both in terms of the CBI action which is going ahead. In terms of clawback, will of course I doubt the contractual arrangements at that point of time had clawback arrangements. So whether you can have clawbacks without any contract prescribing it. So all these issues, there'll be kind of 10 other questions which will arise.
Okay, what is the legal position? Has the report to be made public under listing arrangements, listing agreement? Is ICICI bound to make the report public?
Not really. I mean, whatever is kind of has a impact, whatever has an impact on an investor's decision making as to his or her investment would be required to be made, but that doesn't mean the entire report
needs to be made public. Mr. Gupta, do you think that it would be natural for the CBI to demand a copy of the report?
Of course, it will be natural and they will certainly demand. But your question whether it has to be made mandatory in terms of listing agreement, you have example of Infosys. They did not make any of that inquiry report public. But again, I would say one point. The Justice Srikrishna inquiry was not under any court-appointed justice inquiry. It was just a private inquiry appointed by a bank. So Justice Krishna had limited ability to get into the criminality aspect because he would not have been able to get into where Chanda Kocchar has invested or what is the asset. So that way any establishment of quid pro quo was very limited with Justice Srikrishna. So therefore I would say that aspect could not have been examined by Srikrishna of anything.
Okay. In that case, Mr. Gupta, since you bring up this fact as well, it's a private inquiry. Can that be challenged in court, given that CBI has not concluded its findings in the matter yet? You think this will end up in the courts?
It is for the victim, or rather the affected party. If Chanda Kocchar so decides, and if she feels that there was nothing wrong done by her, she can always challenge and fight a case with ICICI Bank. That you're wrong. As we were talking about the clawback. So the clawback, of course, I always believe that any punishment has to be so deterrent that any other person does not think of repeating it. But here, if Chanda Kocchar feels and if she's confident that there is wrong done to her, she can always challenge this inquiry report and file a case against ICICI Bank.
If Ms. Kocchar were to engage you, Sandeep Parekh, do you think she has a case?
See, we're looking at three different things. One is a departmental inquiry, which is what this report leads to, because the report has been commissioned by the company itself. The second is, what we discussed, civil suit in India, abroad, etc. And the third is criminal case, which has already been started and, FIR has been filed. So just on the departmental inquiry, I mean, there are processes in-house on how to kind of appeal against such an order. And if everything else fails, theoretically, maybe, I'm just saying maybe, not definitely, they could file a writ against, I don't know who, because it requires a state. So essentially, it normally would end within the company itself, some appellate mechanism within the company. But, the civil and the criminal will, of course, go on. It's not impacted by what happens.
Sriram, tomorrow we have a market to contend with. What we know is what ICICI has chosen to present us about the inquiry report. And ICICI Bank is telling us that the inquiry report only found Chanda Kocchar guilty of non-disclosure and not recusing herself. And the bank notes, not the committee, the bank notes that there are no implications of the inquiry report on its published financial statements, Indian or US GAAP, for the relevant period. Is the stock, the investor, safe from further suits?
No, there is a definite possibility that the board was derelict in its duty, and so from that perspective, some US hedge fund may choose to file a class action suit. So, but definitely the impact on the financial statements is largely due to the NPA and to the extent of the loans given. But that also can be questioned by the bank, saying that it was part of the consortium and there were other committee members, etc.
And there was a Reserve Bank, review of the event as well. And clearly they must not have found, I mean, we are only assuming, they must not have found any impact on the bank's financials. Otherwise, we would have heard from the central bank. So do you think that the ICICI... No, I'm only saying because the market will have to react. I'm not asking you to give us a share price impact.
So from a financial restatement perspective, I don't think that would be necessary, or there is a need, or there is even a need to do it. Because I don't think that had impact. It's only that the CEO had heel judgment, and the board also chose to sort of admire their CEO to the extent that they did not quickly conduct an inquiry. And so from that perspective, investors will be slightly worried in that sense. But beyond that, I think things is as usual.
Okay, thank you very much, Hetal, Sriram, Sandeep and Mr. Gupta, for giving us your first thoughts on what we have is only a one-page press release on the Srikrishna Committee's report. The key takeaways that the report only finds Chanda Kocchar guilty of non-disclosure and not recusing herself, and a rather severe penalty of clawing back all her bonuses since April 1, 2009. That is the period of the inquiry.
And the fact that the bank's processes were dependent solely on the directors discharging their fiduciary duty. So, solely laying the blame on Chanda Kocchar. I think that is a key takeaway as well, that the processes, they're saying, are dependent solely on her disclosing this information. Okay, well, that's the bank's view of both the report and therefore that its financial statements are clean. We have to see what future course. But the general sense I got from our experts is that class action suits may not come simply because of this, but we will have to wait and see. We'll wrap up this special coverage on the Srikrishna report on Chanda Kochar's role in the Videocon case. We wrap up the special coverage. Thank you for watching.